I just pressed the Let's Go Live button, so let's wait for the stream to fire up all across the fruited plain of the internet. Before we go ahead and get started, got to make sure the tubes are working. Before we get started, got to get the tubes working, and I think the tubes are working, so that's tremendous news. It's a lovely Friday. Let's go ahead and get started, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Govea. I am a criminal defense attorney, and today we are talking about Biden bank subpoenas, baby, and they have gone out, and we're going to go through them in good detail today. We've got 3 segments queued up. We're going to start by unpacking a little bit of what we started to talk about yesterday, which was the impeachment inquiry proceeding. We know that James Comer came out and made his announcement that there was, in fact, going to be subpoenas that would go out for Joe Biden and Hunter Biden, and they are out now. They are released. And so, as per usual, we like to read through these puppies, and we've got the full thing queued up. You can see a highly redacted letter going over to the president, going over to the first son, saying it's time to give us your files. Woo! We love that one. All right, so we're going to go through that in detail, and then we're going to ask ourselves, I thought Hunter told us that he didn't get paid from the CCP, from the Chinese. He said not 1 cent, but we know that's not true. So we'll take a look at the press release, and then we'll go through this article from the Wall Street Journal. They did a nice detail, a reveal on really how all this evidence matches up. And it was retweeted and shared by James Comer, who said, you guys just have to read it. So we'll go through it and see what's inside. And then James Comer is going to react to all of this here at the end of that first segment. All that very good news to start the Friday off. Then we have to talk about an interesting development that's happening out of Georgia. Big Fani scores a victory. What the heck? So she's got a guilty plea now from this guy, and his name is Scott Graham. Took a plea deal, and he's going to be getting probation, not going to jail or anything. But we're going to go through the plea agreement because he was a co-defendant who was connected to Sidney Powell. And so if he is going to be testifying in this case as somebody who's pleading guilty, we're probably going to find in there, I'm not sure about it yet, but probably going to find in the document that he's going to be willing to testify against everybody else. And so if he is a co-defendant who is involved in some of the overt acts with Sidney Powell, then the question is, if he rats on Sidney, is Sidney going to rat on Trump, right? We're following the bouncing ball as it bounces around in Big Fani's Delusionville. So we'll go through the entire plea agreement, see what is inside, but Fani signed off on it, Scott Graham signed off on it, and so his case is going to be disposed of, and we'll go through that. And then we've got an update on the Trump dockets, a couple of them today. First of all, he is not going to be removing his case to federal court. And this was an interesting thing that developed, and some people are like, wow, that's a curious little development. And the question is why? We've talked about Mark Meadows fighting to remove his case. That looks like it's an uphill battle. I think he's appealing that, but he was sent back down in the meantime to go through Fani's court. And so Trump is not going to be following in those footsteps. And the question is why? And we'll read through the short filing, not a lot there, but then I've got some things that I just jotted down that I think might be some justifications for it. Why might Trump want to stay in state court rather than bump this thing up to federal court? So we'll talk about that. Then Trump and his defense team filed a couple of other motions. They are asking for more time in the January 6th case, and we've got 2 of them to go through. One of them is about pretrial motions, so Trump just filing kind of a generic request to ask for more time because of discovery reasons. And remember, this is the case where there's 8 to 10 Washington monuments of discoverable material that Trump's team apparently has to read through. So we'll see what that request is about. But then secondarily, we have another request from the Trump team, which is about CIPA, the Classified Information Procedures Act, and the classified documents, because we recall that there is a classified documents case in Florida. That's with Judge Cannon. But there are also classified materials involved in the January 6th case, separate and apart from Florida. So we have classified documents in both cases, and every time you've got classified documents, We know that there are a bunch of hoops that everybody has to jump through in order to get credentialed and qualified to look at the documents and blah, 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 right? Clearance this and clearance that. So we'll get updated on what's happening in Trump world, but we do have some legal developments, including the one, why is he declining to remove this to federal court? Very, very curious. And so, as you can see, my friends, it is a lovely Friday. We had a busy week. We had our first impeachment inquiry hearing. We had a Democrat senator arraignment. We had a lot of stuff that we talked about. This morning, on our members only stream, we talked about Feinstein dying. We talked about some other things. New York is flooding away, and we had some, question, where are all the illegal immigrants going to sleep now if they're flooded out? So it's, a big problem over there. And we have a lot of fun times at watchingthewatchers.locals.com. And so you can join us over there, and we will get into it after the show here today at our members only after party. And so we'll go through all of that. We also have our new website, robertgovea.com was a great place you can check out, sign up for our daily newsletter. The daily newsletter is where you can get all the news, all the reports, everything we talk about here delivered to your inbox so you don't miss anything. So check it out, robertgovea.com, and we got some fun stuff coming on that website soon enough. Going to be good stuff. So before we get into the show and the heavy lifting, we got to make sure we're nutrified and fortified. And one of the ways we can do that is with our friends at Field of Greens. Now, how sick are you, my friends, of all the ads for weight loss pills and fad diets, right? They're all over the place. We all know we could lose a little bit of those extra pounds that are around us, but we've all tried the stuff, and we've been there. We've done that, and we know that they just don't work. But you know what does? Eating 5 healthy servings of fruits and vegetables every day. You do that, and the weight would probably just fall right off. But look, vegetables, not a fan, and fruit, who's got time to prepare that every day? But look, instead, Field of Greens. Field of Greens is a science-backed formula of specific fruits and vegetables that you're not going to find in any other product. We know that proper nutrition reboots your metabolism so you burn calories faster and lose weight a healthier way. And Field of Greens is the only brand backed by a better health promise. Yes, you'll look and feel healthier fast, but the greater proof is going to come at your next checkup when you walk into your doctor's office and your doctor takes one look at you and says, whoa, you're looking incredible. Whatever you're doing, keep it up. So let's get you started. Head on over to fieldofgreens.com. Don't forget to use code Robert when you check out. That way you can save 15% off at checkout. And let's not forget, the vegetables want to be eaten. That's why they're here on the planet, all right? Look how happy they look. Don't mind the fact that they get blended up and tossed into a field of greens, okay? They're still happy. They still want you to consume them, so make sure you do. Fieldofgreens.com, code Robert at checkout. All right, and now let's get into it. Subpoenas finally go out for Joe and Hunter Biden's bank records, and we're going to go through them in full detail. Been waiting some time for this, but James Comer finally did it, and we heard him say that during the House impeachment inquiry, the historic House impeachment inquiry into the corrupt president called Joe Biden. But the letter that went over to the Biden crime family is now available, as is the subpoenas. So we'll take a look at both of those. We'll also go through the press release. We've got clips from Hunter Biden saying that he really did not take 1 cent, not one, from China. And there's other stories about really what was happening here, including messages in the middle of transactions where they were saying the big guy is calling me. We all know who that is. But first, before we go through this document, look how redacted this thing is. We've got a couple here and there, and it's just a nice, big, beautiful letter from James Comer and Jim Jordan, along with the subpoenas, which we'll take a look at. But this was the press release over from James Comer. Here's what he said when he published this historic subpoena. On September 28th, he says, as part of the impeachment inquiry into Joe Biden, our committees have released this subpoena, 3 of them, for Hunter and James Biden's personal and business bank records. Oh, so not the president's. My mistake. Correction on that. Hunter and James Biden's, not Joe's. Oh, my apologies. Hunter and James. So correction on that. From day one of our investigation, Joe's abuse of public office, so that's a little less exciting, but still exciting, We followed money, and that continues with today's subpoenas for Hunter and James Biden's bank records. Bank records don't lie. And coupled with witness testimony, they reveal that Joe Biden abused his public office for his family's financial gain. And so, okay, so if it's only James and Hunter, that's still okay because you still have one side of the transaction, right? You still see both sides of the ledger. You can say, well, where'd this money go? What bank account did it go to? And obviously the receiving end would be of Joe Biden's. So the financial records obtained to date reveal a pattern where Biden and the family sold access to Joe Biden around the world to enrich the Biden family. As the Bidens were sealing deals around the world, Joe Biden showed up, met with, talked with, shook hands with, and had meetings with the foreign nationals sending money to his family. This culture of corruption demands further investigation, and so the Oversight Committee has done that. Now, they've been releasing a ton of stuff. We've talked about several of these things, including the different bank record memoranda that have all been dropped out there. But this is the actual set of documents that were released. Let's get to it. Subpoenas to James and Hunter Biden coming from Congress of the United States. And we saw James Comer authorize these, but here is the letter and the documents. We got a big redacted paragraph right here, which would include certainly the people who are receiving the document, probably the Biden crime family's lawyers. And they say, hey, dear representatives, or maybe James and Hunter, they say the Committee on the Oversight and Accountability and Judiciary and all of us, we are subpoenaing certain financial records in the possession, control, or custody of so-and-so, and so-and-so, and so-and-so. Okay, these subpoenas are being issued at the bank's request and pursuant to the authority of the chairman on the various committees. They say the committees are seeking records related to Robert Hunter Biden, here called Hunter Biden, James Biden, and Eric Sherwin. So three individuals, Hunter, James, and Eric. And Eric, of course, was a business family associate. As part of its investigation, the Oversight Committee has reviewed bank records of individuals and entities associated with the Biden family as well as other evidence. This review uncovered a pattern of financial complexity, as detailed in the impeachment memoranda, which we looked at previously, and the Oversight Committee's bank memos, which again we've looked at. The Biden family used corporate bank accounts and third-party associates to receive wires from foreign companies and foreign nationals. The Biden business associates then dispersed money to various Biden family members in incremental payments over time. So you'd have the foreign companies would send all the money into one big kind of depository. They'd hang on to the money and then dish it out. Your allowance is this, Hunter. Here's some more money. Last thing you want to do is give Hunter access to a ton of money. Otherwise, he'll spend it on crack and hookers. So while much of this money went to Hunter Biden's professional corporation called Owasco and his other bank accounts, other Biden family members and their companies received significant payments as well. Who are these people? For instance, the Oversight Committee has confirmed that Robinson Walker LLC received payments from foreign companies and individuals and then made payments to Owasco. So they go to that company and then to Owasco. Other Hunter Biden bank accounts would get the money. Hallie Biden, JBBSR Inc., another corporate account associated with James Biden, also got paid. The Oversight Committee has traced payments from Burisma and entities related to the CEFC, a Chinese energy company, to the bank accounts of Biden business associates, and then the money was sent to redacted accounts belonging to Hunter Biden. Money was sent to blank accounts belonging to Hunter Biden. All right? We're going to put a pin in that because Hunter swore to us that he did not take one dime. And he lied to us all about that in the middle of the campaign. In fact, let's just pause right there and hit that segment. Here is what he told us when he was being interviewed about this before the election, lying to us through his teeth to all of America so that they could cover this up and his daddy could get elected.
List of accusations against Hunter Biden? That Hunter flew on Air Force Two with his father during an official government trip to China in 2013, leveraging that connection for financial gain in an investment deal with Chinese businessman Jonathan Lee. The president has repeatedly said that you received $1.5 billion from China despite no experience and for no apparent reason. Obviously, fact checkers have said that that is not true.
Look, this is literally has
Not
no
true.
basis in fact in any way.
Have you received any money from
No.
that business dealing?
No.
At all? Not
No,
1 cent?
Not 1 cent.
Definitely not 1.5 billion.
It's crazy. They feel like they have
Not
the
1
license to
cent.
go out and say whatever they want. It feels to me like living in some kind of Alice in Wonderland, where you're up on the real world and then you fall down the rabbit hole, and the president's the Cheshire Cat asking you questions about crazy things that don't bear any resemblance to the reality of anything that has to do with me. And so here's the answer. No one ever paid me $1.5 billion. And if they had, I would not be doing this interview right now.
Okay, 1.5 billion. That's a lot, right? That's a big number. Maybe it's not 1.5 billion, but he said not 1 cent as he lied to us all. And as ABC sat there and said, well, that's good enough for us, I guess. So they just shut up and they, went back to the election and they said, Trump's a monster. And I guess he's a racist, whatever. So we know that's nonsense. Now, the committees are concerned that Hunter and other Biden family members sought to conceal the source of foreign income by having lucrative wires sent to Biden's associate accounts instead of their own bank accounts and at this bank and elsewhere. We believe these records will provide insight as to where the foreign money was finally sent. On September 12th, Speaker McCarthy directed the committees to open up a formal impeachment inquiry, and we've done that. Now, evidence shows that Joe Biden was at least aware, obviously, of at least some of the family's business ventures and sought to influence potential business deals that financially benefited his family. Right? Isn't that something? Like if a parent does something and their kid gets something from that, like, isn't that a benefit to a parent? Like, I obviously don't have kids, but like if you did something, you did in exchange for that. Like parents sacrifice all the time for their kids, right? And that's a benefit to the parent as well. It's like, man, I don't have to worry about my kid anymore. He's getting paid $83,000 a month from some company. Great. Finally off daddy's payroll, right? Like that's like a benefit to him. So Joe Biden is getting a benefit by exchanging in these brand deals. Like it's just obvious, but anyways, I digress. Indeed, a Biden business associate, Devin Archer, testified how the Biden, quote, brand was used in retaining business. And the Joe met with some foreign nationals who paid his family. It's like, great. Which is a benefit to Joe. Accordingly, the committees seek additional information regarding the use and the ultimate destination of these funds given Joe Biden's involvement with the individuals who are paying these companies, and ultimately his family members themselves. The subpoenaed bank records will help the committee determine whether Joe Biden himself abused his office by selling access or by receiving payments or other benefits in exchange for official acts, which is a critical aspect of our inquiry. The records sought by the subpoena will also assist in our efforts to craft legislative solutions aimed at deficiencies that have been identified in the current law involving the immediate family members of elected vice presidents and presidents. Deficiencies that might jeopardize American security. And so these records will help our committee get information critical to address the systemic failure to protect against foreign interactions with senior elected officials. Specifically, we're concerned that foreign nationals and foreign companies like CEFC and Burisma appear to have sought access and influence by engaging in lucrative business relationships with high-profile political and immediate family members. The committees are also concerned about the national security implications about the VP's immediate family member, or president now, receiving millions of dollars from foreign nationals without any oversight. Current disclosure laws and regulations do not require non-dependent family members to provide any information to the public. That's a problem. So meaningful reforms to government ethics and disclosure laws are therefore being explored here in Congress so that we can assess their assets and the financial relationships when this stuff goes down. In particular, we're going to be developing legislation that would strengthen reporting requirements involving foreign transactions so that we don't have problematic disclosures. And we also want to prevent financial transactions from being structured and layered in a way that could evade review, especially for a period of time after they leave office. They say the reason these subpoenas are necessary as well is we're also going to be strengthening the Bank Secrecy Act, which provides anti-money laundering tools. And the point of that is to thwart illegal money laundering. In particular, we're evaluating whether SARS reports, the suspicious activity reports, generated by personal or corporate bank accounts that are associated, here it is, with the president or vice president's immediate family members could or should undergo more rigorous banking compliance rules in order to comply with the needs under national security requirements. We aim, says James Comer and Jim Jordan, we aim to draft legislation that provides more transparency to the American people, deters foreign interests from attempting to obtain influence over the highest levels of our government, and discourages family members from profiting from their relatives' public service, making sure our nation is safe from our foreign adversaries. They say, in short, the records sought by these subpoenas are critical to both the impeachment inquiry and to further the committee's purposes. As chairman, we urge you to cooperate speedily and in good faith with these subpoenas, and if you have any questions about it, give us a call and let us know. Sincerely, your friends, James Comer and Jim Jordan, Chairman, Oversight and Accountability, Committee on the Judiciary. And so it's hard to see who they were exactly writing to here. Let's see what the subpoenas say. We go down and we see that these puppies got dropped. Here they are. Subpoena by authority of the House of Representatives and Congress. Drafted here that you are hereby commanded to appear before Oversight and Accountability. But who did this go to? It's right here. It's redacted. To redacted. Who is that? Hang on, we're going to continue going down here. Where's the other subpoena? What the heck is going on here? Okay, so I guess they redacted their names off of the subpoenas for some reason, which is a little interesting. Like, that's the good part, man. They redacted the name? What the heck? Why is Hunter Biden's name not right here? Why is that redacted? They told us where they're going. I don't know. All right. So here they say somebody, I'm presuming it's Hunter or James Biden, as they tell us, but I don't know why that's redacted. I mean, they could have redacted the address, but at least let us see the goods. Let us see the good part, man. The heck is this? They say somebody, I guess, is going to show up and produce things identified here, touching matters of inquiry by October 12th. Okay, so produce things identified to the documents attached. Here's the schedule. All right, whatever. Signed by James Comer here. We can't even see who it went to. Says, here's the schedule. In accordance with the attached schedule instructions, the custodian of records of this whatever entity and this entity, so the banks. So are these subpoenas to the banks now, or are these subpoenas to the people? Is this why they're being coy about this? Is this why they're being coy about this? They issued because they probably went to the banks. Okay, so today issued 3 subpoenas for bank records. But they told us, this is weird, because they told us in the same document that it was for these 3 people. All right, let's see if we can figure this out. Hunter and James Biden. But we saw the 3 names, Eric Sherwin, James Biden and Hunter Biden. All right, let's go back and just see what they're doing. So here, we get a very lacking feeling subpoena. Here's what they want. All financial records, including but not limited to account statements, records, all the stuff related to these entities. Robert Hunter Biden, Owasco LLC, Eric Sherwin, James Biden, Lion Hall LLC. So these 3 subpoenas, I think we were inferring that they went to the 3 individuals. but they might be going to 3 different banks. Like this bank. They're not telling us the bank. In accordance with this, the custodian of records of this is required to produce the following documents. So all things related to James Biden, all things related to Lyon Hall. So it's going to be everything, okay? Whatever they're asking for, and I really wish we knew where this was going specifically. Like, is it a bank? Is it a person? Is it a lawyer? What bank? What person? What lawyer? It's very obscure, right? They just say it's related to their records. Now, wherever it's going, we're going to see that there are a lot of things that they're asking for. Like, are they asking Hunter's legal team to prepare this and James's legal team to prepare this? Are they asking the banks to prepare this? Or are they asking Hunter and James themselves personally? But here, right, we've got a bunch of stuff. So debit cards, cashier checks, wire transfers, electronic transfer payments, CC numbers, signature cards, copies of IDs, anything, any account closing documents. What makes me think this is going to a bank is because they're saying, like, your due diligence documents, right? Like, what did you do on your end to do your due diligence? KYC is know your customer, know your client. So I think these are going to banks now. For business accounts, any other corporate identification documents. So it looks like these are going to the banks. Dear Mr. Who is this? Dear Mr. So-and-so, certain financial records in this entity's possession, custody, or control. We're seeking records related to Hunter Biden as part of the investigation. The same thing here, as detailed, very much the same letter. And the final letter, look, another subpoena. Who is that going to? Must be banks. Same thing here. In another bank or entity, all the documents, yeah, here it is, that are in the bank's possession. That's what it is. They're going to banks. So this is Robert Hunter Biden. So they didn't actually get subpoenaed. The banks got subpoenaed. And this is what Comer said, though. We will continue to follow the money. We will continue to provide answers and transparency. All right. So anyways, they're going to the banks. Recently, I thought he's already done this. He subpoenaed and obtained 2 bank wires revealing Hunter Biden Bank received payments originating from Chinese nationals. Yeah, the bank subpoenas. Okay. Anyways, my friend. So that's what's going out now. This is a little bit weird to me. Like, I understand why they don't want the banks to be made public, but he kind of is making it sound like he subpoenaed them, not their banks, is the way that I was reading that originally. But he's not doing that at all, right? He's not subpoenaing Hunter or James. He's just going after their bank records, which I still think is a good thing. It's less exciting than I thought this was at the start of this segment, but I still think it is very fruitful because I think this is where they're going to find the fruits. All of the evidence really is going to be in the bank records. Like, the bank accounts are going to be the gold bars, to use the Menendez analogy. The Menendez analogy, he had gold bars. This is happening in LLCs and bank accounts. Now, Hunter did get other things. He got diamond rings, he got sports cars and other stuff like this. But yeah, this was a little bit, a little curious there. Anyways, the point is there is a lot of evidence on this one. And this came over from the Wall Street Journal. And they tell us that this thing goes pretty deep. They say how Joe Biden's kin profited off the family name. They say the big guy is calling me. And here's the story. During 5 decades in public office, they say Biden has built his political brand on the working class roots. And over that time, members of his family capitalized on his political success, and they got millions of dollars. Now, they did their own examination here, the Wall Street Journal, and they say that certain family members and their year-long pattern of trading on the powerful name is at the center of this impeachment inquiry. They've denounced the inquiry, but the Journal's examination of the Biden relatives' dealings didn't turn up evidence that he benefited from the enterprise, but at least a few occasions before his presidency, Joe Biden was more present in his family business dealings than he or they have acknowledged. Of course he was. They were talking about the weather. And let's see, do they have this little diagram for us? Yeah, they have this little family tree. All right, Biden is the oldest of 4 siblings. His brother, James Biden, along with his son, they built Chinese oil company ties. They ran a hedge fund. James also worked for the firm attempting to build homes in Iraq. Youngest brother, Francis Biden, sometimes interrupted meetings by saying he had to take a call from the big guy, right? The younger brother, Francis Biden. A Florida-based law firm that employs Francis ran a newspaper ad trumpeting its relationship with the president's brother. An episode that drew a White House rebuke, right? Everybody's latching on to him. Hunter developed overseas relationships. Burisma paid him $1 million a year for nothing. Family members would take phone calls from Joe Biden during their meetings, a practice that many was interpreted by some who witnessed it as an attempt to show off the connection, right? He would just call. The conversations that involved Joe were largely limited to pleasantries, according to those around him. But it is true that he had regular calls with his family members to check in. There aren't rules that prevent politically connected families from using their name, but that's not exactly all they were doing. Here at times, business partners were ultimately disappointed when the Biden name failed to unlock certain things. And a spokesman for everybody says, we haven't done anything inappropriate, right? But they all were in on it. The whole thing is just gross. Very, very extensive. So here's James Comer giving us some more information, some more background on what they've done with these subpoenas.
James Comer, let's go over the evidence, and there's a lot of it. To sum up the biggest evidence that you and your committee, and you had a great couple of lines in an opening statement today that I think everybody needs to see, talking about the bank records. Tell everybody watching right now, what evidence do you have?
We have bank wires that show that Bidens took $20 million from foreign nationals in at least 5 different countries. They can't say one thing they did to earn that $20 million. We also have evidence that they started 20 shell companies. They used these shell companies to receive the wires from the foreign nationals. And then, according to the banks, in the 170 different suspicious activity reports, those were the bank violations, they then took those wires through the shell companies and laundered them down to the Biden family, to 9 different Biden family members in incremental payments. That shows money laundering. That shows a lot of problems with respect to influence peddling. And it's interesting, Sean, in your monologue, you showed the clip from Dan Goldman. He admitted that the Biden family was influence peddling. And he admitted that Joe Biden lied. And he's, was really the basis for our first hearing, to justify why we're going to impeachment inquiry and to prove that Joe Biden lied over a dozen times about his knowledge and involvement in his family's business schemes, and to prove that this family was influence peddling. And I think every American has a problem with the fact that our president's family was selling access to him to our enemies around the world.
All right, so we have
No,
Shell
they were
Corporation
just talking about the weather.
go north of maybe $50 million for the Bidens alone?
Well, we've got to get to Jim Biden, and that's why today I signed the subpoenas to subpoena Jim Biden's personal bank accounts. He's flown under the radar because, quite frankly, he didn't leave a laptop laying around. But we know from people we've talked to, from evidence in emails and text messages, that he, too, was just as involved as Hunter. Byron Donald showed that text message today from Jim Biden to Hunter Biden when Hunter was going to rehab again. He said, don't worry, I'll work with your dad. We'll finish those deals. I mean, there's overwhelming evidence that Joe Biden was involved in all of these shady business schemes. That's a problem. Yeah. That's a threat to our national security. And today we rehashed and went over all the different items of evidence, and we announced the subpoenas. We're going to continue to move forward and follow the money.
Jason.
All right, we'll see if they get anything. So those went out to banks, not to James and Hunter, and they're going to their banks first. They're not asking them to get anything. And so we'll see if the banks respond. I'm sure that there will be a lot of legal challenges over this. I can't wait to see what Abby Lowell does and what the Hunter and the James defense team do. But the story is James and Hunter Biden get subpoenas for their bank records, and we'll continue to cover this. We're just getting started. I think once the bank records start to unpack, we'll see where the connections really come into play, and there'll be a lot of litigation over this. We'll continue to cover, my friends. Thank you for subscribing and joining us. Thank you for going to robertgovea.com, signing up for our daily newsletter so you never miss anything that we talk about here. Get it all delivered to your inbox, and we'll look forward to seeing you on the next one. All right. Now, we've got an update on what's going on in Georgia with Big Fani Willis. Big Fani Willis gets a victory. She's got a guilty plea from this fella. His name is Scott Graham. And people are a little concerned about this one because not only is this a guilty plea, but this guy may or may not have to testify against other people as a part of this plea deal, which we're about to read through. And if that is the case, he is a co-defendant who is a part of the overt acts that involve Sidney Powell. Sidney Powell, we know, was a major lawyer in the 2020 litigation. And if he testifies against Sidney Powell, that puts pressure on her. And we all know where they're trying to go and who they're trying to get, Trump. And she's just one step away from Trump. And so we're seeing if this is a domino that might lead to consequences for the president. So this is what the plea deal looks like. And we'll go through it in some detail here. But it is signed out of Fulton County Superior Court, filed and entered 9/29/2023. The case is Big Fani versus Scott Graham. You see 5 different counts here. Conspiracy to commit intentional interference with performance of election duties. Judge, of course, is McAfee, and we've been following this for some time. Big Fani Willis, the biggest DA, the biggest Fani in all of Georgia. Fulton County, big county, and there's no bigger Fani than Fani. And so she is the person behind this plea deal. And this is also curious because we can see that they are actually extending plea deals. And they're giving us some of the facts here. They say, all right, well, here on behalf of Georgia, Big Fani Willis is the prosecutor. She charges Scott Hall with the offenses of conspiracy to commit election interference. Various dates, December 1st, 2020, January 7th, 21, saying he unlawfully conspired to interfere and delay the performance of a certain duty, in this case, Misty Hampton, aka Emily Misty Hayes, from doing her duties. Now, this is where you see the co-conspirator. And co-conspirator, boom, Sidney Powell entered into a contract with this company called Sullivan Strickler and caused them to tamper with the electronic ballot markers and the tabulation machines. So they hired a company to come in and do their own analysis. That company, they say, interfered with the machines. Sidney Powell was a co-conspirator because Scott Graham aided and abetted this new company to come in here and do all those things, right? So if he takes a plea, his plea deal, he's going to come, theoretically, we'll get to the rest of the plea deal, testify against Powell. Powell will be the person who they'll put pressure on to get her to plead guilty. So she testifies against Trump. Same thing here. I think these are the various counts. Okay, so it's going to be the same story. That was just count 1. This is count 2. Various similar arguments, similar charges, right? Here, Sidney Powell, Scott Graham did the same thing. Sullivan Strickler, LLC. Count 3. Same stuff. Unlawfully conspired, created a interfered, Scott Graham. Various, each various action is a different crime. So they're all basically the same, just different permutations of the same charge. Yeah, so like you can see here, just to make sure we're clear on what the different charges are. Like this one is examining personal voter data, right? That is the part of the overt act. Examining voter data without authority of removing voter data. So like looking at it and then removing it is another count. And so they're all just little permutations. Without authority was taking the information and the software. So it's just a little slight different act, right? Oh, that's a separate crime. Oh, that's a separate crime. Oh, that's a separate crime. They had no lawful right to possess official ballots outside of a polling place. Another overt act, right? All right, so we get the deal. Now, he's taking all of those. Similar thing here, count 5. Fani Willis makes all those allegations, and this is what the remainder of the documents look like. So, Fulton County Superior Court, request for related cases. We have the indictment number here. It's all here. That's what we've got. Now, yeah, so this looks like some form stuff, like some just regular form stuff. So that is what the deal looks like. I mean, that is what was submitted in court today. And so let me just take a quick look, someplace else. And see if we can get some more information on that, because that was kind of bare bones. Here is what MSNBC tells us. There was a proceeding that took place today. His bond was originally set, and here's what the AP is reporting. This is what I was hoping we'd find, but it sounds like he's going to be required to testify. So a bail bondsman charged alongside former President Trump pleaded guilty to misdemeanor charges, first defendant to do so. He's going to get 5 years of probation, and he agreed to testify in further proceedings. He was also ordered, look, to write a letter of an apology. Oh, gosh. I'm sorry for insurrecting America to the citizens of Georgia, and he's forbidden from participating in polling activities. So he pleaded guilty to 5 counts of conspiracy, the ones that we just read through, to commit intentional interference of election duties. Prosecutors accused him of participating in breaches of election equipment. Now, he's one of the lower level people, but the question is his indictment and conviction now going to be used to put pressure on the other people? For example, Sidney Powell, and then ultimately Donald Trump. His attorney, who was in court with him on Friday, did not respond to messages. Trump lawyer Steve Sado referred a request to comment to somebody else who didn't respond to a comment. They say that this guy who pled guilty was a longtime associate of Trump, and the security breach in the county was when Trump allies were trying to access the voting systems. Authorities allege that the breach took place on January 7th, the day after the violent assault. And here's the deal. Yeah, Nathan Wade, which is the same prosecutor who's getting paid big bucks by Fani, who used to be Fani's mentor, revealed at a separate hearing that the district attorney's office planned to offer plea deals to Sidney Powell and Kenneth Chesebro. Yeah, because if they could get Sidney Powell to plead and testify, they're going to get her to turn on Trump. Attorneys for the pair were present at the hearing and didn't indicate whether the clients would accept the offers. Powell and Chesebro have requested speedy trials. They're set to be tried together very soon in October. Despite their lawyers arguing they didn't even know each other, they're scheduled for trials rapidly. Powell's accused of also helping in the breach and so on. So we'll see if this goes to trial or if they take plea deals. But the fact that they're offering plea deals and the fact that he took one means that she's getting some of her witnesses in order, right? She's getting him available to testify against whomever, and we'll, of course, continue to cover it. So, new plea deals in Big Fani's case. Thank you for subscribing, my friends, and we'll see you on the next one. All right, and now we got one final update on the day, and this is also related to Trump. Donald Trump is going to be declining to remove his case to federal court. And we followed some other co-defendants in Big Fani's RICO prosecution who have made this attempt, like Mark Meadows, Trump's former chief of staff. And he had a difficult time with this. His case is back down in Big Fani's court. And we're going to see why Trump may have decided to stay here as well. It is a very short declination filing we'll read through. Then we'll explore some of the possibilities as to why he may want to remain in state court. But then he also filed in a different jurisdiction requests for more time. In Washington, D.C., in the January 6th prosecution, Trump has been ordered to prepare for trial and to read multiple Washington monuments worth of evidence prior to the trial because the judge, Chutkan, who has failed to recuse herself, she decided she was doing a great job and is going to stay on the case for a while. She said that it was highly organized and that prosecutor Molly Gaston did a great job with her highlighters. Trump's people say, not good enough, okay? We need more time. We can't read 10 Washington monuments worth of copy paper in 6 months. Give us some more time. There's 2 filings on that we'll take a look at. But the quick one, easy, is the immediate filing from Trump's lawyers. Look how short this is. Stephen Sado filing this in Big Fani's Fulton County, state of Georgia, versus Donald Trump. They say President Trump's updated notice about removal of his prosecution to federal court. We were thinking he would want to remove to federal court, right? We're kind of in like amateur hour land here in Fannyville, and nobody knows really what they're doing. It's kind of a free-for-all RICO case. Trump wants maybe federal immunity. Trump wants, maybe executive sort of privileges that he might enjoy up in the federal district that he's not going to get at the state level. So this comes as a surprise. They say on September 7th, Trump's lawyer, in an abundance of caution, Trump notified the court that he may seek removal of his prosecution to federal court, and that his notice of removal would need to be filed in federal court on or before September 29th, 2023. Well, that's today. President Trump now notifies the court that he will not be seeking to remove his case to federal court. What? This decision is based on his well-founded confidence that this honorable court intends to fully and completely protect his constitutional right to a fair trial and guarantee him due process of law throughout the prosecution of his case in the Superior Court in Fulton County, Georgia, where Big Fani and the judge reside. Respectfully submitted, Steve Sado. That's it. That's the whole thing. Making sure the court is aware of it, copying all the parties, and that's it. So we're thinking, well, that's curious. I wonder what the heck is going on this one. And so we've got a couple things that I jotted down that might be possible. One, obviously, Donald Trump probably does not want to testify at the removal hearing. So when Mark Meadows was trying to remove his case, he needed to testify so that he could talk about his role, and so that his role would articulate that he was operating within the confines of a federal officer, a federal official, and the federal official operation justified the removal, right? So it's kind of, he's got to explain to the court why it needs to be removed. Trump definitely does not want to testify right now. If he testifies right now, he's kind of fair game for a lot of stuff. And he may not want to testify at all, as is his right. But in order to have I would say, a higher a chance of success at federal removal, he would need to testify. Mark Meadows did it. Mark Meadows didn't win. Trump is a different category. Okay, he is actually the president. And so I think kind of a lot of the things that he does are totally within the confines of that role. But for whatever reason, he's not going to make the decision to do that. So one reason might be doesn't want to testify. Number two, judges, right? Now, I've read that the federal court judge who's assigned to this case is an Obama-appointed judge. Obviously, more experience, been around for a lot longer. In Georgia, we've got a new judge, Judge McAfee, right? Young, 34, 35 years old, right? Fresh on the bench. And there's also some talk that maybe he is actually a little bit more conservative. Like maybe he's got connections with the Federalist Society or something like that. Well, now, if you think the Federalist Society is favorable to Trump, or like, let's say, wants Trump to win again, I have a different opinion on that. But generally speaking, right, maybe it's a choice of judge. They like the state judge better for tactical reasons. Maybe they think the judge is, less experienced and they can take advantage of that. Maybe they think the judge is more politically favorable and that's beneficial to them, or whatever reason. Maybe they just want to avoid the federal court judge because it was Obama appointed. Could be a possibility. Another possibility that we talked about this morning on our members only morning stream is about the appellate path. And if Trump loses anything, first of all, what is he losing? What would the downside be? What is he trying to fight and then lose? What is the issue at stake? And does the issue that they're fighting over, does it originate from state law versus does it originate from federal law? And so if they're at the state level, they might say that the current laws here are more favorable to us, so that if we lose in Georgia, we'll appeal to the Georgia Court of Appeals and then to the Georgia State Supreme Court and then maybe to the the United States Supreme Court. So work their way up from within the state to the Supreme Court rather than take themselves out of the state and go through the federal courts. And one reason they might want to do that is because in federal courts, in my opinion, things are a little bit more professional, right? Things are a little bit more dialed in. Stakes are generally a little bit higher. The the level is just a little bit more, it's like, from going from college to the pros a little bit, although it's not quite that dramatic. It's like maybe from regular season to the playoffs or something like that is a better analogy. But the point is, it's a little bit higher games, the stakes are a little higher and it's a little bit more dialed in. So if that is the case, the federal judge may be somebody who is correcting some of the problems, identifying them and correcting them as the case is progressing. Whereas if you're at the state level court, it's kind of a circus down there and you just kind of let the whole thing go. And we know it's kind of a circus because their justice system is pretty broken, right? People are dropping dead in Big Fani's jail. It's kind of a mess there, right? The whole county's kind of a problem. So they might want to operate in that space because it's a little bit more chaotic, a little bit more unknowns that might pop up, and you can exploit those unknowns. Greater propensity for mistakes, greater propensity for chaos, and that's exactly how Trump likes to operate. And lastly, one final reason, TV, maybe they want TV. And somebody brought this up on Locals this morning, shout out, who said maybe Trump just wants a spectacle. In federal court, he does not get to have TV as it stands. So his Florida case, not going to be on TV, presumably. His January 6th case, not going to be on TV. I'll be surprised if his New York case even goes, if they get convictions on the other federal cases. And so maybe he wants to go, let's do it. You want to talk about fraud in Georgia? You want to talk about broken water mains that are popping off in the middle of 2 a.m. conveniently on election night? That's weird. Why did a water main break right as we're counting votes? Strange. What a coincidence. So maybe he wants to bring in these conversations and talk about it and present it to the American people and get the full exposure of the truth. So it could be any one of those things, could be reasons we haven't thought about, but the point is Trump is not going to be removing his case. So we're going to be sticking around in Big Fani's court for some time, and we're probably going to see this trial on TV. Hey-yo, which is good news. I think that they were thinking that this would be bad for Trump. Let's see it. Let's see Big Fani out there, if she even does this, okay? If she even prosecutes this case, she'll probably have somebody else do it, all right? We'll see. Now, we'll see if she's in trial for Sidney Powell or Kenneth Chesebro. I tend to doubt it. But in other jurisdictions, Donald Trump is asking for more time because there are tens of millions of pages. Is that right? I think, I don't know if that's that accurate, but it's 10 Washington monuments. That I know is accurate. Multiple Washington monuments full of documents that they are supposed to read. And Trump is saying, we need more time to process everything, and we need more time. Judge Chutkan, who has failed to recuse herself out of the District of Columbia, they say, we need more time. We need an extension. This is from Trump's people, to file pre-trial motions. Now, if I could predict the future, I'm going to guess the judge is going to say no. Why? Because it's Judge Chutkan. They're asking for 60 days. Let's see. Although this is just a pretrial motions deadline, so she might bump this back a little bit. Let's see. Let's see what their argument is. They say here, we've got a current motions deadline coming up, like October 9th. Can we please postpone that 60 days from now to December 8th? And it's just a pretrial motions deadline, Judge, so it's not trial. It's not anything major. We just need more time to investigate. Here's why. As you know, this case presents numerous novel and complex legal issues. I'm not even sure the judge would agree with that, though. Counsel has been diligently researching these questions and preparing the appropriate pretrial motions, since we've never indicted a former president, current presidential candidate before, and tried to gag him and then cram a trial down America's gullet in a matter of months. All right. But this requires a brief extension of time, Judge, just to complete the process. For the reasons below, Trump seeks the requested extension to ensure that he can raise all the relevant legal issues consistent with his Fifth Amendment right to a fair trial and to present a full defense. The prosecution has already advised that Jack Smith objects. He opposes our requests. Typical. Trump's defense says, Your Honor, this case is the first of its kind, and it concerns many legal questions of first impression. This is the first time in history anyone, let alone a president of the United States, has been charged, in the defense's view, wrongly, with conspiracies related to a contested election. Never happened before. It is also the first time that a president has been charged for conduct committed while in office, and the first time that a leading presidential candidate has been charged in the middle of a campaign by his opponent's administration. All true. Factually. As a result, defense counsel must research and address issues of extreme constitutional import that require careful analysis and briefing. And despite due diligence, counsel requests additional time to address these complex and novel legal questions and to ensure that they are properly placed before the court. Because, Judge, you want everybody to have a fair trial, don't you? We have due process in this country, don't we? You don't want to stop his attorney from being an effective assistance of counsel. This additional time, therefore, will conserve judicial resources by providing defense counsel the necessary time to assist the court in fully understanding these novel issues. Judge, we're going to help you. If you allow us to brief this now, then when it comes time for argument, we'll be able to present it much more competently. You know, it's like when you're painting. Painting can be a big pain in the butt if you don't prep right. If you prep the room and you do it well, painting's pretty quick and easy. But it's in the prep time, Judge. So we got to prep this whole thing out. Then when it's time to do the painting, we're all just going to grab a couple of rollers, boom, and paint the whole thing up. But let us tape the room off. We need 60 days to do it. It will allow counsel the necessary time to ensure that all questions are fully researched, fully examined, and fully briefed. They say, Your Honor, at the outset of this case, the court requested that the parties propose a trial date estimating the time required for trial. And we submitted extensive briefing on the respective trial date proposals. At the hearing, though, the court and the parties focused on their respective views about when trial was appropriate. And at the conclusion of the hearing, Judge Yu announced that your decision was to set trial for March 4th, 2024. Immediately, basically. But Judge Yu did not hear argument about other deadlines. Instead, the court indicated that they would just issue an order and schedule a bunch of the other stuff, pretrial matters, motions, deadlines, status hearings, whatever. So the judge basically said, we'll backfill the dates. I want trial on March 4th. Why? Because March 5th is Super Tuesday, the day before all of the primaries in this entire country. So as people are going to go in to vote on March 5th, Trump's trial for January 6th will have started on March 4th. If you don't think that's if you think that's coincidence, I mean, you know, amazing. And she did it, right? And then she said, once that date is anchored in there, so I can cause maximum damage to the Republican Party, we'll just backfill the dates and just schedule them whenever because it doesn't even matter, right? She said, what do I care about motions? The court advised, however, that its initial deadlines would not be set in stone, but if the parties had conflicts, we could alter them. They say, Your Honor, that's pretty sensible. It's going to allow the parties the opportunity to assess their potential motions, including how much research and drafting time it would take to prepare all the stuff. And they say, Your Honor, good news. We have had time to do this analysis. And Trump's defense now advises that it requires an extension. And we have to finalize several of our expected motions, including motions to dismiss this case related to executive immunity. And I know some of these cases have felt like they're a little bit slow, right? Where are these motions at? Where's the motion to dismiss and all that? They're coming, right? They're all coming. Failure to state a claim, improper conduct by special counsel during a grand jury process in charging decisions. Subpoenas are going out. Motions to compel discovery, etc., right? And that etc. is a monster list, all right? So they're gearing up for it. But all of this is just foundational stuff that's working out. And every time they ask for an extension, right? I love that they're doing this, just to zoom out for a minute, because the judge is going to deny it or deny to some extent some of these motions. I don't think she's going to come back and say 60 days, 60 days, 60 days. She'll come back, okay, how about 2 weeks? How about 30 days? And every time they do that, Trump is basically anchoring in that you are causing us to be ineffective. Literally. There's no way we can read 10 Washington monuments of documents. There's no way we can prepare all these pretrial motions. How can we prepare a motion to dismiss the case if we don't know what the evidence is upon which to base our motion? So they're forcing the judge to deny them due process, essentially. So each of these motions will be extensive, no doubt about it. You better believe it. And although counsel has been working diligently to meet the existing motion deadline that you set kind of haphazardly when you scheduled your trial very early, it is now clear that President Trump will require this requested extension to fully address the complex questions raised by the unique legal issues in this case. Additionally, Trump believes that his pretrial motions will be more efficiently and appropriately considered sequentially and on a rolling basis. And all motions have thus far been considered, as they all have, rather than a single burst before an arbitrary motion deadline. So let us submit one, we'll have a reply and a response, and we'll do it again. But we don't need to batch them all together and drop like 5 motions on one day. In this regard, Trump anticipates filing certain motions in advance of this and not waiting until the last day. So this extension would provide additional time that would benefit everybody. In other words, by postponing this, giving us 60 days, you're not actually going to have to wait 60 days. We're going to start dropping these things, but just sequentially. So you can start reviewing. Court, you can do your due diligence, and so can the prosecutor. Finally, Trump's defense has begun the process of reviewing vast amounts of discovery in this case, which is now, 13 million pages of documents. 13 million. And I don't know how many Washington monuments that is, okay? They helped us with the math last time, but it's more than last time. We might be 12, 15 Washington monuments. I don't know how many million per monument. Somebody could have to do the conversion because I can't math. While operating under an unprecedented trial setting mere months from the time of the indictment, 13 million pages. How is that due process? The government had time to read all of those. That's why they put them in their discovery files. Why doesn't the defense have the same amount of time? This is a time-consuming task requiring considerable attention, Judge Chutkan, which diverts substantial resources from motion practice because we have to sit there and read War and Peace 25 times a week. Defense counsel needs the time necessary to review this discovery and assess the potential import about the various motions we intend to file. We're unlikely to have even made a small dent in this review by the currently scheduled pretrial motions deadline. Maybe they'll get, I don't know, how many hundreds of thousands of pages can they get done by October 9th? Not many. An additional 60 days will enable defense counsel to review larger segments of the provided discovery, request additional discovery from the prosecution because Jack Smith is going to deliver a wheelbarrow, right? He's going to just dump it on their desk. And they're going to say, okay, we're going to go through it, but we're going to need 5 more wheelbarrows because your documents reference that guy and that guy and that guy and that guy, and you conveniently left all that crap out. Thanks, Jack, but go get it. These tasks, we also have to address matters relating to confidential and classified documents. These go to the heart of Trump's constitutional rights, which nobody cares about anymore, except here, to due process and effective assistance of counsel. We can't do our job if we can't do our job. The reasonable adjournment here would be consistent with a fair and just trial for President Trump. Objectives that the court says it believes in, while not prejudicing the prosecution in any way. And they give us some arguments, right? They say here, Jack Smith would not be harmed at all. It would not affect any other deadlines. The case would still be on trial. I'm not asking for a removal of the trial date, but that's going to come. The prosecutor, not yet, of course, because they haven't been harmed enough. All they're asking for is just a couple deadlines, extensions. and then when they have, 11 million pages of outstanding discovery, then they're going to have the continuance of the trial motion will be coming. The prosecution would have equal time to file pretrial motions, so they'll get 60 days too, including those that are going to be complex, right? So presidential immunity issues and other things. The extension would also allow these motions to be filed sequentially rather than at once. And if this extension is granted, it's ordinary order. It's not abnormal. Everybody can still file their motions. They say this is far from the typical case, okay? Trump is not asking for the entire pretrial period. He just wants a brief extension. And here, They say this is not causing the government prejudice at all. The court should strike a proper balance. They notify the judge. The government opposes the motion. Jack Smith and Molly Gaston over there say, sorry, judge, this is an egregious violation. We have a speedy trial. The public has a right. Any response under a standard briefing schedule would be due after the current pretrial motion deadline. And so they say, judge, we've got deadlines coming up. Please set a briefing schedule to hash out this issue. In conclusion, President Trump respectfully requests that the court grant the requested extension and give us until December 8th to file our pretrial motions 60 days out from October 9th. Signed here by John Lauro and Todd Blanche, two Trump lawyers representing the president. And so this is just one half of the equation. You can see that they are going to be asking for a lot more time. Now the total number of documents is up to 13 million, which is just insane. And you can do the math on that. They did that in prior motions. It's like reading, I think, War and Peace dozens of times a day per lawyers. You know, it's great. We did the math. It was crazy. But it's only one half of this thing, because there was another filing from Trump's defense as well. This one is saying we need more time also as a result of classified documents being involved in this case. So it's a similar extension request. And the reason I pause on these, I know these are not like, juicy headline motions, like motions to dismiss and motions to preclude or whatever. This is timing and technical motions. But this is going to be where a lot of this, I think, is made, like where the egregious violations are made. Trump not having enough time, his counsel not being able to defend him, all of those are due process violations. And the judge is going to really be driving this bus hard to get us to trial on March 4th. They do not want that date to move. And it's basically, in my opinion, it's impossible for Trump's defense to provide him an adequate defense by that date. It's impossible. But 13 million documents, you can just do the math on it. You need 100 lawyers to read all the documents 24 hours a day for months, right? You just can't do it. So every time they file one of these, it's just like a little speed bump in the process. And that, you get enough speed bumps on the road and it really can deviate the whole experience for the government. And it provides every one of those speed bumps, is really a basis for appeal. Every time the judge denies Trump the ability to actually read the evidence, he has a new argument. So here, 10 pages. This one is now involving the classified documents. They say, Judge, again, we're seeking a fair opportunity. We just want a fair shake at this. We want reasonable adversary proceedings that can happen here. They say, as you know, CIPA authorizes the court to provide protective orders, allowing prosecutors to delete otherwise discoverable classified materials. So if Trump wants something that is in this batch, they can say, oh, it's classified. I delete it. You don't get access to that because it's deleted. As of today, Jack Smith's office has not disclosed to Trump or defense counsel the type of relief it is seeking or the types of documents that are at issue here. So we want to know what they've got, basically. The standard here says that Trump cannot fully develop his defenses until after we've had an opportunity to review the discovery. For the first time yesterday, Trump's defense says, cleared counsel for Trump, very first time, was permitted to review classified discovery that was provided by Jack Smith in this case. Just got it. And it is now at the end of September, and they are racing to trial in March. Our review was brief and preliminary. We got to see some of it. But it's clear that President Trump is entitled to additional materials that are possessed by the U.S. intelligence community and other executive branch actors. They want to delete this stuff because they don't want us to see it. He says, we're going to request from that office, and if necessary, we're going to go get it. We're going to provide motions to compel and other procedures to go get what they have. They want to delete it from their batch, but we're going to go get it anyways. However, the court information security officer has informed us that restrictions on one of the central documents in the office's classified production currently preclude us from writing to the court or the office about the document's substance in connection with these applications. We do not know when those limitations will be addressed. So they say, Judge, we have identified a piece of paper, a document that we want badly. They say that they're going to delete it from evidence so that we don't get access to it. That's fine if they're entitled to do that. We're going to go through other places to get it, intelligence community and other executive branches. But we can't even bring this up with you, okay? We can't even talk about this document that we're going to talk to you about, or we want to talk to you about, because there are restrictions on talking about the document. So we can't even tell you about we can't mention or talk about the document in our request to you. So we're letting you know. It also appears that other classified material exists for several witnesses, including but not limited to classified emails that witnesses in this case exchanged around the time of the events in question, January 6. Jack Smith's office did not include those classified materials in its first production of classified discovery. In other words, Trump's defense has identified classified information that is probably pretty damning to Jack Smith. Jack Smith is not including those. And they're saying, Judge, classified witness-related materials will likely require litigation, and we're going to fight over this. In other words, they're not giving us the stuff that we're asking for. We know it's there. We're going to go get it somewhere else. They're not disclosing it. And we can't tell you what's in it because the rules say we can't talk about classified documents. So therefore, Trump objects to ex parte proceedings. So the government has been sending little love letters over to Judge Chutkan and saying, this is why we need protective orders. Trump can't get access to this stuff. Trump can't talk about this stuff. Nobody can see it. Protect this case under CIPA. But Trump is saying, no, you can't do that. No secret love letters, nothing ex parte, nothing happening without the other side. You got to go through everybody. They say, yeah, the law says that there is discretion by the court to authorize some aspects of various motions to be filed ex parte, which means the government is sending the motion only to the judge and not copying Trump on it, which you're supposed to do. General motion practice, when you file, you notify the other side. That's why when we talk about other motions, we say the other side objects to it, or the other side takes no position on it, or the other side is in agreement with it. And then the judge doesn't have to think about it, right? Oh, they agree? Perfect. I also agree? Granted. But here they're just bypassing Trump. They don't want Trump to see what's in it. So Trump says, I object to this ex parte proceeding. No little love sessions between the judge and the DOJ. It is not a foregone conclusion that ex parte proceedings are appropriate. We can't have that. But the special counsel say that they object to our request to brief this subject. So they're just saying, Judge, you can have the ability to schedule ex parte proceedings. We know you can, but we're telling you why you shouldn't in this case. Can we please submit a brief on this? That's it. Can we please provide a brief to explain why we don't think you should do it that way? Government opposes. So they say Trump objects to unjustified and unnecessary sealing. Why is everything ex parte? Why is everything sealed if they want Trump to be prosecuted openly and in public? If he really insurrected America, shouldn't we all see it? So Trump's defense says, Your Honor, to facilitate the appropriate adversarial process and to respect the public's right of access to these proceedings, this court should order Jack Smith to file publicly a redacted version of his CIPA submission. What is he trying to protect? What is he trying to keep us from getting? Why is he going to you ex parte? Put it on the docket so we can all see it. And two, order Jack Smith to write a memorandum of law with argument and authorities about the basis for the redactions so that President Trump can address those contentions in his other submissions. If they're going to be sending these secret love letters to the judge, post them and make him justify why it needs to be redacted. Now, of course, Jack Smith objects to this request because he would rather have these secret conversations with the judge, and they don't want the public seeing any of this. Although we recognize that some aspects of CIPA do likely contain classified information. No doubt, I'm sure it does. There's no basis for the special counsel to file its entire thing ex parte. Just file a part of it. You can file it on the docket, but let's leave the redactions in rather than just not even allowing Trump to see any of it at all. They give us a bunch of rules here. And they say here, it's strange credulity for Jack Smith. We don't believe him to suggest that it's unclassified arguments, right? Things that are unclassified portions of the whole document. Other things like citations to legal authority or any proposed orders that you're going to be ordering on us. Why does that have to be hidden from Trump and the public? It's strange credulity. In addition to Trump's due process rights, open access principles under the First Amendment and at common law require a very different course for a CIPA filing that is obviously a very important judicial record. Special counsel should be required to file a public version of this motion and justify any redactions so that Trump and the public have an opportunity to respond. What's so hard about that? Why can't we just see what they're doing? They keep telling us that it's all America needs to know, right? I think even Adam Schiff's like, we need to have cameras in the courtrooms. Fine, we're fine with that. How about you unclassify, unseal, and stop your ex parte secret messages? They say President Trump is going to seek a hearing on this submission. So when Jack Smith submits his secret love letter, they say to the extent the court authorizes Jack Smith to send this in secret, in whole or part, Trump is now respectfully requesting an opportunity for an ex parte proceeding to discuss our theories, which is great. Judge, if you're going to grant them secret meetings, we want our secret meeting. The special counsel's office does not object to such a hearing, but it contends it has to take place in the next 2 weeks because they want to go fast. But that timeline is not appropriate, Judge, and we request the court refrain from setting this deadline until after Trump's objections, after they've already been addressed. Why is this not appropriate in the next 2 weeks? A couple reasons, Your Honor. One, 2 members of Trump's defense team have not even obtained clearances yet, and they're unable to even look at the classified discovery. And you've also created a compressed schedule because Jack Smith requested it. We've got trial coming up in March. Trump's Sixth Amendment rights require all lawyers to be in a position to review the discovery. And you have not gotten our people certified. Second, Jack Smith's office is not in compliance with its discovery obligations with respect to the classified materials. So Trump cannot plan his defense in time. In order for Jack Smith to comply with these obligations, they've got to get all their disclosures done. Bunch of rules. Now, third, as noted above, in light of restrictions on one of the central documents in the classified discovery, we are presently, Trump's team, foreclosed from making applications to their office related to the substance of the document. Okay, we want one of these central documents in the classified discovery. We can't even talk about it. Thus, we anticipate transmitting discovery requests and motions to compel, but we're not in a position to pursue those mechanisms because we can't see it. We can't talk about it. So, Your Honor, in other words, we're going to be filing a bunch of additional stuff, but we can't do it now because of the rules. So under these circumstances, even if the restricted handling issue is addressed promptly, like our attorneys get certified, the 2-week deadline proposed by Jack Smith is not reasonable. It's not an efficient use of judicial resources. There is no fair reason to move so quickly on this. And if the court does take the course urged by Jack Smith, subsequent disclosures, if you make us go fast on this, we might have to revise our defense strategy, which again would cause us to have to go back and revisit other things. So for those reasons, do not set deadlines until after Trump has made and reviewed the files. They say, finally, President Trump respectfully requests the deadline be adjourned 3 weeks. President Trump expects to include information from classified discovery in his notices, so Trump needs to review things before he's ultimately able to respond to them and file them. And it would be inefficient to do things backwards. So, therefore, in conclusion, They say the court should order Jack Smith to file a redacted version of its motion online on the court docket. Let us all see it. And if anything is redacted, he should be able to justify it. Refrain from addressing the CIPA stuff until Trump has had an opportunity to file his objections and make any ex parte submissions of his own, and then adjourn this for 3 weeks so that everybody comply with disclosure obligations. Everybody on the defense team. Signed by Todd Blanche. And this is good stuff. Coming from Blanche Law, New York, counsel for President Trump. This is good. This is good practice. I mean, you can see how technical this is. They're making all of the good arguments. There's 4 of them here, I think 5 of them. And every one of these, the judge is probably going to reject, right? Rejection. Third, rejected. Fourth, rejected. And I'm going to guess she's going to just keep siding with the prosecution. And I'm not sure that we're going to see, these documents be posted on the public docket at all. But the point is, these are each speed bumps. And every time the judge comes back and we think it looks like we're getting an adverse ruling against Trump, every one of these arguments is going to form the basis of an appellate argument to say that they were denied due process. They could not act as effective lawyers because they couldn't do their jobs. They had no time. They had no resources. They didn't even have the actual files. Like, they couldn't even read the classified documents. And they can't even talk about the documents to make their arguments. So it shatters their legitimacy. Every time the judge rules adversely, and I'm sure there will be more of these, it is another indicator that this whole prosecution is just illegitimate. Now, this is what the docket looks like. Catching the latest. Let's see if there's anything most recent on this one. But this is what they have for us. They say the judge has set hearing dates on both of those filings. On the CIPA ruling, they said it is hereby ordered that by October 3rd, the government shall respond to Trump's request. And on the pretrial filings, they're scheduling a hearing on that one. Actually, this is the protective order hearing. So we've got hearings in October 3rd and October 16th. And the government will respond to both of those motions from Trump. He declines to remove this to federal court, but he's asking for more time in D.C. And my friends, we will continue to cover this. I hope that you join us. Thank you for going to robertgovea.com to sign up for our daily newsletter. In case you miss anything here, you can get the daily reports delivered to your inbox. And we'll see you right back here on the next one. All right, my friends. Well, that is it for us on the day. We covered some good ground. We've got some interesting updates out of Trump world, and I actually like those motions a lot more than I thought I would. So we're happy about that. We had an interesting plea deal. There was a little bit bare bones on that one, but this was also an interesting one, kind of a little bit of a bait and switch on this, I think. So we got some bank records that are going out, and I do think that the bank records are going to be very important. I'll be looking forward to some more subpoenas for the actual Biden crime family members. But now it is time to hear from you and to see what you have to say about all of this over from our friends on YouTube, our friends on Rumble, our friends on Locals, of course, at watchingthewatchers.locals.com. We have a great members-only community over there. We would love to see you come and join us. We do member-only morning streams. We have Saturday shows that we do. So tomorrow morning, we'll be back here to get into some other topics on the weekend. But who do we have coming in supporting us with some love on this Friday evening? Thank you to Alicia O in the house. Alicia O, who just became a member over on YouTube. Alicia O, welcome as a supporter. We're glad to have you. We got Wendy Sloan. Say, what's up, Wendy? Says, thanks for all the great analysis. Thanks, Wendy. Thanks for being here. And thanks for sending in some great donos. Wendy S. in the house. Appreciate it. Hopefully you're having a beautiful, beautiful Friday, Wendy. We got Dolphin Fan is the man, bringing in 5 new membos. Woo! We got Mama Pillow. We got Mary M, Deanna G. We got Cyprian C and Clyde B, all coming in courtesy of Dolphin Fan is the man in the house. Thank you, Dolphin. Hopefully you're having a beautiful day as well. We got this one from Knox Bierman. Says subpoenas could be addressed to the custodian of records. Yeah, it could. Yeah, it was kind of a weird, it was the bank, it was a custodian. I had a hard time figuring out who that was, but yeah, ultimately it's the bank, and then it's probably the custodian of records, or like their, what are they called? Their statutory agent, something like that. So it could be curious. The Lion Hall Group, somebody clipped this one. The Lion Hall Group looks like it's another LLC company founded by James Biden. Annual revenue, $146,000 on that company. That's from John McGarvey. Thanks, John, for sharing that one. That's curious. That's curious. GSD ladies here says, this is how you follow the money to set the case up for future subpoenas with this as evidence. Remember, there was something like 1,000 SARs that were generated by the Bribin family over the last several years, which used to be reported to Congress, but it is one of the first things he signed as an executive order to change, so now they don't get them unless they file for them. Yeah, and I think a bunch of people on the Oversight Committee or the Ways and Means Committee, they were going to the Treasury to actually investigate the SARs, and they were looking at them, right? So they've seen them, but I don't think that they can share the information from the SARs. Like they can't copy them, copy and paste them and then deliver them out to us. So they're just there. They're just sitting at the Treasury. And the question is, how do we get those out so that everybody can see them? We got Jigum's in the house. What's up, Jigum? Says, stupid question, maybe. Probably not. Says, without knowing exactly what, quote, influence they traded for money, is anything they did actually illegal? Is there actually a law that your son can't be a foreign agent while you are a vice president or president? Not good practice for sure, but is it illegal? So it depends on what conduct you're talking about. But yeah, I think you could identify a ton of conduct that was illegal. And I think that's just on the one side of this. I think that there's plenty of evidence to show that Joe Biden engaged in bribery, like literal bribery. Same thing that we saw with Menendez, like easily. His son got paid money. His family got a benefit for the name of Joe Biden, and Joe Biden fired a prosecutor, and Hunter leveraged that $1 billion in order to do that. So what the left wants to do is they want to separate Hunter from Joe. It's not. Okay, they're the same. If they're going to charge Trump with a RICO conspiracy with 18 other co-defendants, same thing here. Charge the Biden crime family. Charge them as co-defendants. They're all part of the same deal. Hunter does not get paid. James does not get paid if Joe is not doing something. And so you can identify what those are. And the most obvious one that stands out to me is Burisma, Shokin, Ukraine. I think that is obvious. And there's $83,000 a month. The timelines all match up. Hunter was cracked out of the place. So I would say it's absolutely illegal. And some other things might not be. Like there's probably a ton of other conduct in there that is highly unethical, disgustingly inappropriate, but probably not illegal, right? I think that the structuring is all the structuring that was done, it's all done with Joe Biden as like the center of it. James Biden doesn't have anything without Joe. Hunter doesn't have anything without Joe. So you're looking for the conduct. And again, I think that the bank records will probably bring to us evidence of more transactions that are suspicious. And I think personally, I have a sneaking suspicion that James Comer knows a lot more than he's letting on. I think he's probably being coy about a lot of this, and that they're just walking through the timeline into the next election. But it's a great question, Jigum. I don't think it's a stupid question at all, because this is a very common talking point that exists. Now, to add another layer to this, it's also about obstruction. Okay, so I also think that what Joe Biden has done is obstructing justice, right? He has basically used his influence to prevent his family from being prosecuted, in addition to the ultimate crimes. So as the president, I don't know, exactly how it happened, but we should start working up that chain. Leslie Wolf, should be investigated, impeached, probably charged. You know, if she was really deviating the investigation so thoroughly, it's like she's got 3 whistleblowers who would probably testify against her. So then you go to her. Who was her boss? Was Merrick Garland in charge of this, right? Who was orchestrating this? Merrick Garland appointed David Weiss. What's that all about? And David Weiss worked for Beau Biden. So that's a Biden family connection as well. So I think you can draw the connections any which way you want. The idea that Joe Biden is so far removed is, I think, just laughable. Like, he is the centerpiece of the whole thing. And they just say because he's not gotten the big checks or gold bars that he's immune from all of this. It would be like a bunch of drug dealers running around selling a bunch of drugs, but there's no drugs. What are they doing? The drugs is just the influence. That's all it is. And Joe Biden, I'm sure Joe Biden, probably didn't do the same things that Menendez did. I'm sure I don't know about that. I don't know. I don't know. I'm sure he made some phone calls. I'm sure he showed up to certain things. I'm sure he made certain statements to certain people. We know Hunter Biden was sending letters and stuff like that. So I think that there is plenty there. It's a great question, Jigam. Thanks for asking it. Posh says, Big Fani is working that Stairmaster tonight. No doubt about that. I mean, she definitely got a big victory. I don't know what she's doing tonight. Probably celebrating. What are they doing over there in Fulton County? I don't know. It's Friday night, going out for Fanny champagne or something, whatever they're doing. They got their first guilty conviction or guilty plea. Hey, Tony Hay Munkets. Oh my goodness, bringing in 20 new membos. Tony Hay. Oh my goodness. Thank you, Tony, for doing this. Look at our new membos. We got Catania Mama Italia. We got One Nation Underground is in the house. We got Rogue Rose. We got Stop Sniffing Kids, Joe. We have Maynard, Trevor L. Keister Bunny's here. Greg E. We got Ron H. Ian M. Rage Star. Adam K. Confessions of a Cookie Addict. Happens. Dano, Father M. Jason H. Wild Horses. Charmaine Lily, Mary, and Ben Dover, all in the house, courtesy of our friend Tony Hay Munkets. 20 new membos. Tony, thank you so much. Very generous on a lovely Friday, and I'm glad that you did that. Hey, new members, see you tomorrow on our members-only morning stream, which is going to be taking place on Saturday. Should be fun. And then we also have our after party. So YouTube members who are joining us on YouTube, join us on Telegram. So grab the Telegram link, go to the community tab section, download that, and we'll see you there on the after party. We got Stop Sniffing Kids, Joe. Says, bad day, but your show makes it a little bit better. Been a member for 5 months. Man, Stop Sniffing Kids, Joe. Sorry to hear that. Some days are good. Sometimes some days are bad. But at the end of the day, it's just another day, and we go to bed. We close the chapter, bookend that day closed. Tomorrow's a fresh new one. You got a whole fresh new morning, a whole new fresh day ahead, new hours. And so tomorrow will be better. It always is. I hope you have a good night relaxing. Stop Sniffing Kids, Joe. Sometimes we're a little hard on ourselves, or, show yourself a little grace. Get some rest. Do something good for yourself. Get a nice scoop of ice cream. Make it 2 scoops. Get some good rest, and we'll see you tomorrow. Thanks for being here. 5 months. Awesome. Over halfway to a baby. We got Bodie's in the house. Says, what happened to Joe Tacopina? That's a good question. Was he on his New York case? He's had a lot of lawyer changes, but I think Tacopina was on the New York Alvin Bragg case. And we haven't heard much on that one. That one's pretty stagnant for now. So that's a good question. I'm not sure where he's been. CF Rob is here. Says maybe Trump is hoping they will not give him due process and not receive proper discovery, violating his right to a fair and just trial. Would the case be thrown out if Trump was treated unfairly? So exactly right, Rob. Yeah, that's going to be their argument on appeal. They're going to say, Your Honors, at the Court of Appeals or at the Supreme Court, this is totally unconstitutional what they did to us. Why? No due process, no right to counsel. Right? You're violating constitutional rights. You have a right to counsel. That means you have a right to competent counsel, right? They don't just throw you some 4-year-old. Well, he's a lawyer according to the laws of Fulton County, Fanny. No, you need to actually have counsel. And one of those parts of having counsel is they can read, the evidence. Might be good. Good to see you, Rob. Sweet Revenge says tax his cigarettes, tax his beers. If he cries, tax his tears. Sounds like a lefty rhyme. Tax his cigs, tax his beers. If he cries, tax his tears. Tax his life, tax his wife. Tax everything and cause him strife. All the things. It's a nice poem. Thank you for that, Sweet Revenge. Memo for 2 months. First month's the hardest. Second month is easier. We've got this one from Tony. Hey, another one. Tony, very generous today. Thank you for this. Says the communists, first thing they did was destroy our culture. When I was a kid, we all hung out at the store. People sat out on their front porch and said hello to people walking by. Today, we have this chat. God bless America. Thanks, Robert. Man, what a great comment, Tony. Hey. They are trying to destroy our culture. They're doing it all over the place. They're trying to destroy our language. They're destroying our borders and our culture. And it's a difficult thing to watch, but I think part of their efforts are to de-energize, to suppress the enthusiasm. Elections are about enthusiasm and turnout and energy more than anything. And they're trying to suppress our energy. And we're not going to let them do it. We're going to keep joining here digitally. At some point, we'll take this physically as well. And we'll start to do some more things offline, at some point, I'm sure of it. So, Tony, hey, it's great. These conversations will continue. I appreciate you being a part of them and joining us and being so supportive of our work. Have a great day and a beautiful Friday. Rob says, take all the Washington Monument stack of documents and stack them up inside the Supreme Court and ask them to go through it all in this amount of time. See my GIF posted on Telegram from Rob over there. I'll take a look at that after the fact. See, Rob. Thank you for that one. Yeah, see if they can read them in that amount of time. No doubt. Salty Sarge over on Rumble says, Trump has the lawyer budget to counter the overwhelming might of the government. Chutkin can learn about the process being the punishment, hopefully. I think there's a lot of truth to this, Salty. I think that, if anybody is going to take the entire brunt of the United States government, Trump is suited to do it more than anybody. He has the mental fortitude to do it. He's got the money to do it. He's got the people behind him to do it. So that's probably why they're doing it, right? I think any other person would have buckled already. Trump just keeps going, man. And there's something to say to that. Like, it's really, really quite incredible, actually. Thanks, Salty. C. John says, 5 new membos are coming, courtesy of C. John. He says, you're coming in here. True American, Mike D. We got Loud Eddie. We got Furious Mess. And we've got Creed is here. We have Seraph Creed is joining us in the house. Seraph Creed in the house. Good to see you, Seraph. And thank you, C. John, for bringing in 5 new membos. And I'm not real sure what this thing is. So we'll leave that one off the screen because kids. And King Ginger is here. Trump is going to win in an absolute landslide, says King Ginger. I hope you're right. The margin has to be so great to overcome the margin of fraud. And I'm hopeful that we get there. And I'm on that energy with you. Let's go. Let's go get it. A member for 3 months. Good to see you, King Ginger. We got to win. We got to win. There's no other choice. We got First Amendment is here. Says, if there wasn't anything done wrong, they would provide all the documentation without hesitation. Well, if they say Trump is such a monster, why can't they just show us all this evidence? Oh, give him access to this stuff. I mean, if they got him dead to rights, if it was so clear and everybody knows it, then why can't they just let us see it all? Why do they have to hide everything? Because they know it's fake. Woodchip Bill says, why can't the Bidens be charged under RICO? Well, I mean, I think they probably could. I think they really could, but you'd have to find a prosecutor who wanted to do that. So you'd have to find some analog, some Republican version of Fani Willis. you know, the Republican AGs and the Republican county attorneys, I think that they don't want to go down that. They don't want to bark up that tree, in other words. But certainly they could. Why not? Here, a boy misunderstood says, did Joe get 10% from his niece Caroline, guilty of racking up over 100 grand on a stolen credit card from 2018? Felony conviction, sweetheart deals, 10 days community service from a boy misunderstood over on the YouTubes. Thank you, a boy misunderstood, and thanks for being a member on this. I don't know. I don't know if Joe did that. You know, I think that there's probably a ton of that. Like, Joe Biden didn't have a Joe Biden credit card that Joe Biden's credit card would use, and then, you know, all of that money, like he'd say, hey, Hunter, I racked up a ton of money. Can I get some of that Burisma cash, son? And then Hunter transfers, you know, half of his monthly fee. Like, I don't think that's what's happening at all, because they're not that dumb. But, you know, Joe is probably enjoying a lot of the fruit of that money. Okay, Hunter's buying it and Joe's driving it or whatever. Okay, Hunter's paying for that trip, Joe's going on it, right? There's benefits that that Joe is enjoying, but he didn't. Nothing actually changed hands, but the family knew what was going on there. Rob says, I feel Obama was involved in this Hunty RICO bribery case. Obama's net worth 2008 1.6 million, today 70 million. Dems say it was all earned from book deals and speaking engagements. Yeah, right. Well, I saw Michelle Obama got 700 grand for 1 hour. 700 grand for 1 hour. Now, she had to travel to Europe. Probably all that was paid for too. I bet it was $1 million expense. Boom. She takes 700. The rest of it goes to travel and, you know, whatever. It's, oh gosh, crazy. Salty says, anyone who thinks Joe is going to be convicted in the Senate is in for a long wait for a train that ain't coming. Captain Malcolm Reynolds. But in the meanwhile, make them grind their gears. Yeah, I agree. I don't think he's going to be convicted in the Senate either. I don't think there's any possibility of that. But the good news is that he would be also impeached. And so every time that they come out and they say, Trump has been impeached twice, you say, well, so is your president. So what? Nobody cares. Impeach him again. Who cares? What's the big deal? You know, it's all labels. They are label people. They are label people. And oh my goodness, we're posting our shorts on Twitter. Check this out. We're posting our shorts on Twitter now. And let me know what you guys think about that. Should we post these on Twitter or not? On X. Sorry about that, Elon. And I thought we were posting those to all of our community. So I'll check on that one. I thought they were going to our community, not our actual timeline. But anyways, we'll check those out. Who is over on Twitter, on X? We got Fred Pedamontes over there. We've got Danny McWilliams says, am I wrong? A lawyer must present all evidence. I repeat, all evidence. No, yeah, that is wrong. No, a lawyer doesn't have to present all evidence. A lawyer can present evidence that they choose. We got Fred Pedamonte is sharing a pic of his dog. His rascally dog, Johnny, is over there. Here's little puppy Johnny from Fred Pedamonte. What a cute little boy. That was some time ago, right? 8 weeks old. That was the day you got Johnny. I was going to say, Johnny got bigger after that. Danny says, it's really easy. All Trump's lawyers have to do is read every document to the court. Trial will only take 275 years. Troublemaker Jonah is in the house. We've got Al Holman. What's up, Al? Says, another great week of info. Thank you for that, Al Holman. I appreciate you saying that. Thanks for joining us. We've got, oh my gosh, there's a squirrel over on Twitter. There's a squirrel. Here's a squirrel. Somebody shared this one. JB says, watch out, watchers. I've got a squirrel, and I'm not afraid to use it. No, this is a picture of a squirrel. Here it is. On X. There you go. So we've got that. We've got Lucky Jill says, love your show, Robert. Thank you for that, Lucky Jill. And all of our friends on X. And so, okay, so we are posting, it looks like, our shorts over there. Now, I don't know if I like them on the main timeline, though. I think we might post them in the community. Let me see. Are they posted over there? No, they're not. All right. Let's check this. Okay. So we're probably going to start posting those to the community. If you want to join our community, Watching the Watchers on X is where you can join our community. We've got 322 members. and we'll start posting the shorts into the community, not on the main timeline. We'll make that correction. But that, my friends, is it for us on the day. We are going to wrap it up there. Head on over to robertgovea.com to sign up for our daily newsletter. Go check that out. We'd really appreciate you signing up. That way we never lose touch. If anything happens here, boom, at least you get the newsletter. That way I can, send out an alert if something goes catastrophically wrong. We also, right now, going over to watchingthewatchers.locals.com for our members only after party, and we'll be heading there to debrief all of the day's activities. So we'd love to see you and love to have you join. Don't forget to get your Field of Greens courtesy of fieldofgreens.com. You can go and save 15% off with code Robert when you check out. I also want to thank the mods and the meme smiths who mod down the fort for us and keep things nice and orderly. Our friends Vianticus Prime, K Beans in the house, Just Cause, we got Playin' Hooky, we've got Ronnie Cole, Zulu's here, Beyond Geo, Zach Nichols, John Allen, Janik 909, Dog Digger, Donut Mind Me, and John McGarvey, all modding down the fort for us, and we appreciate it. Sleepy Dog Lee, Geegum Geegum, and Nathan N810, all in the house. And one final dono came in from our friend John Allen on the locals. Says, Rob, I have a great thought. Trump's team needs to use ChatGPT to write 100 Washington Monuments pages worth of arguments so the prosecution will get their own medicine. Of course, the defense team will get heavily admonished for it, but it would be an epic troll. Yeah, remember that one lawyer? We talked about that one lawyer who did actually use ChatGPT and it made those fake cases up. Like it just hallucinated fake cases. And they got in trouble for that big time. But it's a funny comment. Yeah, I mean, I think you're right. It's like they should ask for supplemental discovery on all of it so that they have to go get another 10 Washington monuments and deliver that. Anyways, John says, thanks as always for doing such an awesome job, Rob. Wishing you and all the Watching the Watchers group a great weekend. And so are we, John. I wish you a great weekend. Thanks for being a membo. Thanks for being a mod and for helping us all around here. Appreciate it. But that, my friends, is it for us on the day. We are going to leave it there. We are heading on over to watchingthewatchers.locals.com for our members only debrief, and we'd love to see you there. But if not, that's all right. It is weekend time, and that's always a good thing. Always a little bit of a break, time to unplug from politics a little bit, go spend time with friends and family, and get outside, get some sunshine, get some exercise, get some fresh air, all of those things, which I will certainly be doing. As a quick note, next week, the schedule is going to be a little bit wonky. I am traveling next week, going to try to produce as much as we can, but it probably will be not a regular schedule next week. So I'll provide more info on that on Monday. Monday, we will be back for a regular schedule, but then I'm traveling Tuesday through Friday. So I'll keep you posted. I'll know more on Monday about what the plan is, but just wanted to let you know about that here on this lovely Friday. So it is a great weekend ahead. It is an amazing time to recharge our energy, our battery packs, our power levels, because next week we're going to be here, at least on Monday, and then after that, to do it all again, my friends. And I hope to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night and a beautiful weekend, my friends. Sleep very well. I'll see you right back here on Monday. Bye-bye, everybody.